There are a lot of First Amendment urban legends out there, and one of the first ones I'd like to tackle, consider this to be the first part of a multi-part series, is the legend that if you are if you are on the street side of utilities, no matter what they may be or where you may be, you are where you are legally allowed to be. The thought process behind that is something along the lines of the utility company has an easement, and because they have an easement, you can be there. So there's two basic ways the utility companies can get easements. I'm going to look at California law and I'm going to look at Texas law. The first basic way they can get an easement is both California and Texas give utility companies the right to lay pipes or wires across public streets and highways. Public streets and highways. So Texas says over, along, under, and across. California says to lay erect, blah, blah, blah. California has to be a lot wordier, obviously. To lay gas pipes, to erect poles or wires, along or upon a street, yada yada. So they say basically the same thing. The purpose of these two statutes is to change the nature of the easement that the state, county, or municipality received for the road into an easement for the road, plus all of the other necessities that cities and towns and whatnot require. They require gas, they require electricity, they require water, all these fun things. There's no point in trying to make multiple easements when they can just run pipes under the roads and electric lines over the roads or what have you. So both these do the same thing. Then the other way is where they get it off of people and corporations. So in the same section of the Texas Code, this is the Texas Utilities Code. You've got condemnation of property. A gas or electric company has the right and power to enter on, condemn, and appropriate the land, right-of-way, easement, or other property of any person or corporation. And both can happen simultaneously. So the Texas Department of Transportation may require the owner or operator of a pipeline to relocate the pipeline. So Texas Department of Transportation deals with roads. Here it's at the expense of the owner if it's built on the public right-of-way. And here it's at the expense of the state if it's located on private property. This is one of the many California statutes that allow for public utility easement. This is 66-475, and it says there may be imposed by local ordinance a requirement of dedication or revocable offer of dedication of real property within the subdivision for streets, alleys, including access rights and abutters rights, drainage, public utility easements, and other public easements. So we've got some statutes to look at. This is, I'm going to mark this so I can find it again. This is a California case, Sacramento v. Pacific Gas and Electric. So when the utilities are granted these easements, when they get the easement from the state, they end up having to pay the state basically, or the city or county. They have to pay the state a usage fee. So in California, each utility company will bid on the right to use that particular franchise, and then if they win it, then they have to pay the county and cities and stuff that their pipes run through or their electric lines run through for the pleasure of keeping that easement. So in this one, Sacramento thought they were getting shortchanged by Pacific Gas and Electric. It's all big and exciting, but at the end of the day, the important part is all this up here they're talking about on the city streets, and down here we get to where they start talking about the private stuff. The question on appeal is whether the right to use public utility easements is included in the franchises granted by the county. We hold it is not. Public utility easements arise from the terms of Government Code Section 66-475. That's this one. This is where they get it off the real property. which provides that as a condition of approving a subdivision map, a local government may require the subdivider to dedicate real property for public utility easements. Such easements are not granted in the public areas and highways, but are upon the real property purchased by the purchasers of the subdivided lots. Neither the easements nor the servient estate are granted to the county. Rather, the easements are expressly dedicated to the public utility purpose. It is fundamental that the language of the grant of an easement determines the scope of the easement. Long ago, our Supreme Court made it clear the difference between public and private rights of way. Public ways, as applied to ways by land, are usually termed highways or public roads, and are such ways as every citizen has a right to use. A private way relates to that class of easements in which a particular person or particular description or class of persons have an interest or right as distinguished from the general public. Public utility easements, by their express terms, define the class of persons who have an interest or right in the use of the easement, and these easements do not extend rights to the public in general or to the county in particular. For example, you are a homeowner. The utility companies, gas, electric, water, what have you, phone, they have easements onto your property to run their cables or their pipes, to fix those cables or pipes if there's an issue, to check your gas meter, water meter, electric meter, whatever meters. You'll see some homes have a utility box out in front of them that's on their property, and they can't do anything about it. That's an easement that is there for the utility companies. That does not mean that a private citizen can enter those, or that doesn't mean a public person, a general public, can enter onto that private property. The easements only relate to the utilities, the specific utility companies. There's a couple, these are from Texas. There's E.B. Grimes versus the Corpus Christi Transmission Company. This basically holds that the state, if the state has an easement for a road, they have the easement to run the lines and whatnot, but that doesn't mean that they can go outside. They can't expand the easement. They have whatever easement that they negotiated for the road. They could use that whole easement for the pipes and wires and things like that. And then there's also West Texas Utilities Company v. the City of Baird. In this case, the West Texas Utilities Company was using easements over private property to get electricity into the city. They were also going under the street. The court held that the city can't really do a whole lot, but they can control the streets because they have complete access to it from the utilities code, because it says that the municipality gets to approve the franchise. So because they were going under the street, they couldn't do it, but if they had stayed on the all private, then there's not a whole lot that the city could have done. So this is just a quick primer. If you see utilities on the side of the road, that does not necessarily mean that they are part of the easement that was originally granted for the road. A better marker of where you're allowed to be is going to be street signs. If the street ends and then there's a section of grass or shoulder, and then there is a street sign, the easement most likely, typically, probably will go all the way to that sign, because that sign is going to be, if it's a city sign or a county sign or a state sign, it's going to be part of that road easement. The sign, they would have got the easement wide enough that they could place the signage on the side of the road, and they're probably just not using the whole easement. They just have that easement there for when traffic does increase in the future. So I hope this was informative. It is. You always want to check on local plats or whatever kind of maps you can get, surveys, to see where the public right-of-way, the public streets are, how far they go from the center line, to know where you can be. Because remember that a public forum is the streets and the sidewalks and the parks and the plazas. It is not private property. So once you get on that private property, you lose a lot of First Amendment protections. Thanks and have a great day.